DOJ turns against California. 2A bombshell lawsuit hits hard. What if I told you that the federal government has just sued California not to restrict gun rights, but to defend them? It's true. In a historic first, the DOJ's Civil Rights Division is now suing Los Angeles County for deliberately blocking concealed carry rights through massive delays. Over 10 million residents, nearly 4,000 applicants. How many permits were approved? Just 2. This lawsuit isn't just paperwork. It's a legal earthquake, and it could change how permits work in every restrictive state. In this video, we'll break it down. What exactly the DOJ is accusing California of doing. How this lawsuit flips decades of 2A enforcement on its head. Why LA's 0.05% approval rate is being called systematic obstruction. What this means for states like New York, New Jersey, and Hawaii. And how this case could fast-track constitutional carry nationwide. Welcome to Firearms Law Advisor, where legal truth meets your freedom. Like this video, subscribe now, and let's dive into the lawsuit that could rewrite the future of gun laws. Chapter 1. A lawsuit unlike any other. This isn't your typical 2A court battle. For the first time in American history, the Department of Justice itself is suing a law enforcement agency not to limit gun rights, but to enforce them. The target? The Los Angeles County Sheriff's Department. The charge? Systematically delaying concealed carry permits in violation of the Constitution. This lawsuit is part of a broader investigation launched by the DOJ's Civil Rights Division. It's not just about California, it's about setting a precedent nationwide. And with over 10 million residents in LA County, the scale of this case is monumental. Key takeaways. The DOJ filed a civil rights lawsuit against LA County for violating the Second Amendment. The case alleges unconscionable delay tactics that effectively deny CCW permits. This is the first ever affirmative 2A lawsuit filed by the DOJ in defense of gun owners. The complaint could influence how concealed carry permitting is handled nationwide. If this lawsuit succeeds, it could force jurisdictions across the country to rethink how they handle delays, backlogs, and bureaucratic roadblocks for carry permits. Chapter 2. What the DOJ actually found. You may think delays are normal in government, but what the DOJ uncovered in LA County shocked even seasoned investigators. From January 2024 to March 2025, nearly 4,000 CCW applications were submitted. Out of those, only 2 were approved. Yes, just 2. That's an approval rate of 0.05%. According to the DOJ, this isn't incompetence, it's intentional obstruction of constitutional rights. Key takeaways. Out of 3,982 CCW applications, only 2 were approved in 14 months. The DOJ labeled this pattern a deliberate obstruction of gun rights. The median wait time before even starting processing was 372 days. Some applicants waited as long as 1,030 days, nearly 3 years. This isn't just about one sheriff's office being slow. It's about a system designed to wear you down until you give up your right to carry. Chapter 3. It's not just delay, it's denial by design. The DOJ lawsuit doesn't stop at data. It exposes how the permit process was weaponized to deny rights without saying no outright. Applicants weren't rejected. They were made to wait indefinitely. Some never even got interview dates. Others were told to reapply years later. By the DOJ's own wording, this is a constitutional right being rendered meaningless in practice. And the impact isn't hypothetical. It's real people left defenseless while waiting in bureaucratic limbo. Key takeaways. Over 2,700 applications are still pending as of May 2025. Some interviews are delayed until late 2026, 2 years after the initial application. Many applicants withdrew due to endless waiting and unclear timelines. The DOJ stated this violates both California law and the U.S. Constitution. If you have to wait 3 years for a right, it's no longer a right. It's a privilege being rationed by the state. Chapter 4. Why this case is so important nationwide. You might be thinking, I don't live in LA, why should I care? But this lawsuit could be the blueprint for action across the country. Similar patterns have been reported in other California counties, and even in states like New York, Illinois, and Hawaii. If the DOJ wins here, it sends a signal to every anti-carry jurisdiction. Delays are denials, and denials are unconstitutional. This could be the start of a legal domino effect. Key takeaways. Other counties and states use similar delay tactics to limit carry access. The DOJ plans to expand investigations into other jurisdictions next. A successful ruling may pressure states to comply with permit timelines. It could also provide legal ammunition for lawsuits in other states. This lawsuit could be the legal spark that reignites momentum for nationwide concealed carry reform, possibly even constitutional carry. Chapter 5. The Real Fix and Why Permits Shouldn't Be Needed at All. This case raises a deeper question. Should you even need a permit to exercise a constitutional right? The lawsuit proves what many gun owners already know. Permit systems can be manipulated to suppress rights. Even with fees paid, training completed, and background checks passed, the state still controls when and if you're allowed to carry. That's why many are calling for national constitutional carry to end this abuse once and for all. Key takeaways. The LA case shows how permit systems can be abused as delay tools. A permit delayed for years is a right effectively denied. Gun rights groups are pushing for constitutional carry across all 50 states. Legislation already exists in Congress, but faces political gridlock. Until constitutional carry becomes the law of the land, gun owners will continue to face arbitrary and unlawful barriers to their rights, even in states that claim to support them. Chapter 6. California's Silent Ban. Strategy exposed. Even after the Supreme Court's Bruin decision, some states didn't stop restricting carry rights. They just got sneakier. Instead of issuing rejections, they began using procedural traps and endless delays to quietly undermine the Second Amendment. Los Angeles County wasn't alone. These tactics were used across California, and the DOJ lawsuit finally calls them out in the open. Now, every county following this playbook is on notice. The game has changed. Key takeaways. The lawsuit highlights a pattern of intentional delays designed to bypass SCOTUS rulings. Counties used tactics like never-ending interview scheduling and vague documentation demands. This silent ban approach allows governments to deny rights without triggering legal challenges. The Department of Justice's findings threaten to expose and dismantle this coordinated strategy statewide. If you can't ban guns outright, delay them into irrelevance. That's been the approach. But now, that loophole is under fire. Chapter 7. Harmeet, Dhillon's role and the civil rights pivot. This lawsuit didn't appear out of nowhere. It came from within the highest levels of the DOJ's Civil Rights Division, led by Harmeet Dhillon. She's no stranger to constitutional battles and has previously fought for free speech, religious liberty, and now the Second Amendment. Under her leadership, the DOJ shifted its focus from restricting gun rights to protecting them as a civil rights issue. This marks a powerful change in tone, and it could alter how future administrations approach the two. Key takeaways. Harmeet Dhillon now leads the DOJ Civil Rights Division. She launched a first-of-its-kind Second Amendment investigation. Her approach treats delayed CCW access as a civil rights violation. This legal framing opens the door to broader 2A enforcement actions by the DOJ. If gun rights are civil rights, then every state that delays permits may be violating federal law, and now they could be held accountable. Chapter 8. The National Impact. Other states are watching. This case is already rippling beyond California. States like New York, New Jersey, Hawaii, and Maryland are watching closely. Why? Because they've used similar delay tactics for years, hiding behind administrative red tape. Now, the DOJ lawsuit creates a federal template that activists and attorneys can copy in other states. And once courts start seeing consistent data and precedent, these delay regimes could fall one by one. Key takeaways. New York's permit delays mirror LA County's in structure and timeline. New Jersey has a history of discretionary denials now facing scrutiny. Hawaii's long wait times for interviews could now trigger legal action. The DOJ's lawsuit may inspire a wave of civil rights claims in other districts. This isn't just a California fight, it's a national moment. One court win could turn into a tidal wave across restrictive states. Chapter 9. The constitutional carry argument strengthens. This lawsuit reveals a hard truth. As long as permits exist, governments can manipulate them. That's why support for constitutional carry is growing rapidly. Gun owners are demanding that states remove the permit requirement altogether. They argue that if you need government permission to carry, it's no longer a right, it's a privilege. And with states like Texas and Florida already going permitless, the pressure is on Congress to act. Key takeaways. Constitutional carry is now legal in over half of the U.S. Permit abuse cases like LA's are fueling the movement. Proposals in Congress aim to make the national constitution carry the standard. If passed, Such laws would override local delay tactics permanently. The DOJ lawsuit gives momentum to this argument. It proves that even shall-issue states can violate rights through delay and denial. Chapter 10. What gun owners must do now. This lawsuit is a historic moment, but it won't solve everything overnight. Gun owners need to stay alert and involved. First, check your county's permit processing time. If it looks suspiciously slow, document everything. Second, support organizations challenging unlawful delays. Third, stay engaged with local and national elections. Your rights don't protect themselves. And now that even the DOJ is stepping in, there's no excuse to sit back. Key takeaways. Monitor your county's CCW process for signs of delay abuse. Contact local reps and demand compliance with state and federal law. Support legal groups defending the Second Amendment in court. Watch for future DOJ investigations and court rulings tied to this case. This is your moment. If the DOJ is willing to act, then so should every responsible gun owner. The fight is moving fast, and stay sharp. The first of many battles, the DOJ's lawsuit against LA County isn't just a win, it's a warning. A warning to every state using slow permits and red tape to deny your rights. But lawsuits alone won't save the Second Amendment. You have to stay active, informed, and loud. So if you believe this lawsuit is just the beginning, prove it. Like the video, subscribe to Firearms Law Advisor, and drop a comment should the DOJ sue more counties next, or is constitutional carry the only real solution. This isn't over, not by a long shot.